warning, I'll be making mentions of sexual assault, violence, etc. Yeah, so just so everyone's prepared. Okay. Starting my speech in 3, 2, 1. For certain crimes, not proven is too harsh. And for other crimes, not proven is too light. This is actually a reasonably complex debate where people on both sides of the spectrum. Some innocent people will undoubtedly get the verdict of not proven. That will be bad. And some guilty people will also undoubtedly get the verdict of not proven. Our case is that for the vulnerable victims, it is the case that not proven makes it very, very hard for them to prosecute any case against their powerful and authoritative oppressor. And in the cases where the victim is or the defendant is vulnerable, we say that it's far harder for them. It's a permanent black mark on their criminal record and for the rest of their lives. Okay, some rebuttal first. The speech will be segregated first into the direct response. Secondly, how it affects the innocent. Thirdly, how it affects the guilty. First, direct response. They make the broad claim that since there is little evidence for juries to make judgments based on evidence, and since the defendant is often marginalized, juries will then make judgments based on, this lack of information and their own personal biases. So I want to make it clear that the response I'm now going to give are for the specific scenario where the defendant is vulnerable. There are 5 structural reasons why there are already mechanisms against this. First of all, there are metrics in courts to determine to criticize a case that does not have enough evidence. Like, this is basic stuff for a lawyer to just say, look, they're only providing circumstantial evidence. We can provide our own alibi, etc. It's not really the case why you would assume this just because you think this person is of a particular characteristic. You wouldn't do this if you didn't know their identity, for example. Secondly, you only need one jury member who isn't part of this polarized group to challenge it. So even in the worst case where you have a heavily polarized community, you would be extraordinarily unlucky to get 10 racists all in the same jury. But thirdly, the defendant also has some power over the peers where they can discuss with the prosecutor and judge if they feel like some members of the jury are unduly partial before the selection even happens. Fourthly, the judge has the capacity to strike down judgments that do not have enough evidence. And fifthly, as a victim, you can also file a case to the appellate court in the case where you feel like you were unjustly punished because they did not meet a sufficient burden of proof to hold you accountable. I'll explain later why this is an important thing for the reason that the state holds asymmetric power over you and procedural justice must be exceedingly and extraordinarily careful, but the rebuttal simply stands enough to delink all of their material. Okay. First argument, we believe that the concept of a not proven verdict makes life very, very hard for people that are in situations where they need to file a case against someone that is in power, someone that is in a position of authority, but can be hard to hold accountable. Why is it much, much easier for a rich, authoritative person to just get away with things? 2 ways. The first is there's a game theory problem where it's the easy way out for both lawyers to simply just not have to go through the lengthy work of doing this case, to work on some other case, especially if you're a public defendant or a prosecutor, for example. But secondly, it's also a considerably lower barrier for you to muddy the water for you to get a not guilty outcome. Now that you don't have to worry about something like a mistrial or even an acquittal, now you could do things like potentially hide evidence on purpose so that life gets hard for the victim that's trying to file a case against you. And because of the game theory problem, it's far easier for these things to be reached. Why are these bad for the people who are trying to file a case? So this is most common in cases of sexual assault, in cases of domestic abuse. The first impact is that it becomes far harder to make any headway in the case against your oppressor. Now, you might make the claim that, oh no, we have no epistemological access or whatever, like, oh, the trial should be the one to determine and we shouldn't unfairly pre-biased trial. But I want to make the point that we already know that trials right now are currently unfair, that 1 in 10 sexual cases that go to court get the sexual assault cases that go to court get struck down. That now they can instead hide the evidence, attempt to collude with the lawyer to get the easy way out with minimal fuss. This makes things far harder for individual victims of sexual assault, far harder for individual victims of domestic abuse to get justice that is due them, which means that it's far harder for them to get accountability. But the second, and I think more important outcome of this, is that this imposes a chilling effect on everyone who would potentially want to file a case, for everyone who would potentially want to engage in some form of legal mechanism for reparation against the person that abused them, against the person that committed violence against them, for the first reason that it becomes far harder and far more daunting for you to do so. So now not only do you have to get past the hurdle of proving that they are not innocent, but also having to get past the hurdle of proving that they are not proven. So it's for this reason then that life becomes far harder for you as an individual, and it's far harder for people to collectivize. But note that the economic shockwaves of this also means that there are far less options for you as an individual. You have far less people specializing in these forms of law. You have far less people willing to take on these cases. And it's for this reason then that it's just far harder for you to get any form of justice. We think this is unfair and these people are particularly vulnerable. Before I move on to my second point of material, I'll take a POI from OG.
So if it's true that lawyers want to get an easy way out, why don't lawyers just do side settlements like they do already? How is it exclusively worse under your rule?
Well, I think settlements is kind of like the net minimum on both sides, right? But you raise the amount of wanting to get the easy way out, in particular for lawyers that are part of criminal courts. And in particular, it's kind of hard to get out of a criminal case in the first place. So that's why it's different. Anyway, secondly, for the innocent, we also think this is too harsh. Now, they make the point that, oh, if you're a black person, for example, or you are unfairly prejudiced against by the courts, this will be a great thing for you because it means that now you can get out because the jury doesn't think you're guilty. And so, they do think you're guilty, but they don't have enough evidence. So the problem with this, I think, is this is still bad in all the ways that are meaningful for this individual. It is still something saying that the courts and the law think you are guilty, but simply did not have enough the evidence to make life hard for you. So in particular, this is a harm for people that are vulnerable. So this isn't the same harm for people that are rich, because people that are rich are particularly insulated from these things, like your workplace bosses, your professors, and your harassers don't really care about the perceptual harms. But it's the people that are innocent, the people that are poor, the people that need a job, that need to get hired, that need to get rent, that need to get approvals for their loans, are harmed by this permanent black mark on their criminal record. What are the harms that arise from having the state tell someone that they think they're guilty without having a criminal, without having some form of punishment on them? The first is that they look really, really bad because people think that you are a criminal, but they treat you the same as a criminal because everyone else thinks you're guilty. So clearly you must be guilty to some degree. The problem is that future people that have access to this information, whether it be the people that are considering whether or not to offer you a place in their apartment, or like your landlord, for example, or maybe the people that are willing to offer you a job. So all the harms that end up leading to recidivism, all the harms of being isolated and alienated from society, not being able to get opportunities, being forced to steal because you're not given a job, all these things get worse because all the meaningful harms that affect criminals now affect all these people. And I want to note that this isn't the same wedge of people that OG identifies. This expands the wedge of people because it becomes considerably easier to call innocent people who would have originally gotten an innocent verdict not proven because there is some degree of guilt or because of the internal biases. So they actually empower the internal biases by making life harder for everyone that would have gotten away with an innocent verdict, but are now struck permanently with the black mark because a jury happened to think that they were racist. But the second thing is that also makes it harder for you to advocate for a second trial in the future, especially if evidence comes up, since now you no longer have the option of a mistrial, or because since you've taken this verdict, you can't call it a mistrial anymore, and because it'll be harder for lawyers to pursue because they'd rather pursue this instead. So the problem then we've identified for you is that it makes life worse for the guilty, and it makes life better for the guilty, and it makes life worse for the innocent. It's for these reasons then that you must negate. Thank you.
We thank the Leader of the Opposition for that fine speech, and we now call upon the Deputy Prime Minister to continue the case for OG. Hear, hear. The Prime Minister for that fine speech, and we now call upon the Deputy Leader of the Opposition to continue the case for side 00. Hear, hear.
Hello, testing my microphone. Can I be heard properly?
Yes, you're audible.
All right, thank you. Hello everyone, my name is Luigi. My preferred gender pronouns are he, him, they. If you have any POIs, you can raise it in the chat, so I'm gonna watch the chat for all of your POIs. Okay, all right. So in the words of closing government, one point of framing and then the responses will follow afterwards. Firstly, in terms of framing, most likely, in the vast majority of cases in this debate, because debates are judged on the vast majority of cases, no one is going to change on who is going to be presented or be convicted more as guilty on either side of the house. Because the threshold of evidence and the sufficiency of evidence in this debate is beyond reasonable doubt, which is very difficult to already prove or ascertain to someone who's guilty at all in the status quo, because that is why we have a very robust litigation process. So this debate is not only about the sufficiency of evidence changing the threshold, but it's changing and incorporating the belief of someone being guilty given insufficiency of evidence. So what we are talking about in the vast majority of cases in this debate is whether the threshold is going to of meeting the demand of insufficient evidence should be seen as not proven for someone, for a jury that believes that these individuals are actually guilty, but you don't have the sufficiency of evidence to do so. So the binary dichotomy here in the vast majority of cases is between someone being innocent and then someone being not proven, and that's what we talked about opening opposition. So the first thing on constructive I'm gonna go into the speech is why more vulnerable people will be prosecuted or be harmed more and be punished more by the use of this verdict, and why that significant delta is more important for consideration, even if a lot of people like O.J. Simpson are gonna get away scot-free in our side of the house. I'm perfectly fine with that, as long as many vulnerable people who we have a special obligation to, are not harmed in the status quo. 3 reasons why vulnerable people are more likely to be shown as not proven on their model. Number 1, because of sampling bias. Most cases that reach a criminal trial in the first place significantly include minority groups and people from minority communities, because of the fact they need public defendants, because of the fact rich people on the converse can pay off a civil suit from coming in the first place, or they can stop a criminal investigation from elevating or moving towards a district attorney or another person, because of the fact many politicians and district attorneys are hesitant to be able to prosecute these individuals. Number 2, because with insufficient evidence, rich people who are often than not rich people from the majority ethnicity or race will always have the benefit of the doubt from juries, especially if juries come from a jury of peers. So for example, people like Brock Turner, based on how they dress, their educational background, their reputation, how people know them in their community, and because of how people also prejudge them on the media, are also likely to show that these individuals are going to be seen as innocent on either side of the house. But thirdly, because vulnerable minorities are the ones who don't have the financial resources to invest in a robust litigation process to get more and more evidence to be able to defend themselves. For these reasons, the comparative then is, it is better for us to say, in our worst case, that all people in the insufficiency evidence threshold will be seen as innocent on either side, because if they cannot prove that this person is really guilty, they have to give up and show that this person is innocent, because the obligation of the criminal justice system is to do no harm. Because you have a special obligation against minority communities who are disenfranchised, who have not had the ability to represent themselves historically to be in the creation and formation of many of these laws, from the damages that are guaranteed, as what the DPM said, of being in prison, continuously being harmed, being put into prison in a wrongful manner, or not having the political and social capital to be able to have and lobby for a trial in the future. For these reasons, we win the delta. Now let me respond to the other claims that were brought by the previous speaker. Number 1, they said that it is good to have a stalemate. So when we don't know what to do, we reach a stalemate, we can study it later on in the future. So I have 3 responses to try and frame this out. Number 1, because of my first point of framing, their structure or their current stalemate doesn't work for poor people who are already currently seen as guilty but will be demoted to not proven. I hope you understand that, because the framing I presented earlier is that most poor individuals on either side, if they are already in the guilty threshold and there's a lot of sufficient evidence to already prove them to be guilty, will already be guilty no matter what, because there's already enough evidence to do so, and the jury already likely believes that they are already guilty. So there's no change and delta on that side if you want to demote them, because the jury already believes that they're still guilty. That's what the info side says. But 2, the stalemate exists for the promotion of people of sometimes already being innocent. They might have like the threshold of not enough evidence, but the jury believes that they are actually guilty, and then they will be seen as not proven. And that's where the damages that David talked about apply the most. The damages of, number 1, this being permanently on your record, and an employer in the future or someone who is going to understand you and interrogate you will doubt you. In the same way, you have to explain over and over again to more and more people that why a jury didn't believe you and they thought you were guilty, even if there was not enough evidence. That is a damage in and of itself that is permanent for you, that you cannot repair, especially if you try and lobby for more evidence, because that's already non-existent. But 3, because if it is the case that poor people are already improperly, put into jail because of reasons of, the symmetry, inequality, then that's not at the level of sufficiency of evidence, but that's on the level of belief of guilt, right? And that's not what we're talking about in this debate in the vast majority of cases. So the last point of response I want to make, but before this, I'll take closing government if they have one.
So how do you counter the idea that most of the legal systems are not jury-based, but continental-based, where a judge actually makes this decision?
I presume that the motion is set mostly in cases where there's a jury, because the info slide says that the jury is going to decide that they're possibly guilty. So I hope you don't have a big brain extension that changes the entire context or makes it entirely different. I just don't think that works. Second, in terms of working with other worse cases, right? So they said that it is important to retry them and lobby for a mistrial, a second trial, and investigate it further. So number one, David pointed out in his speech that was unresponded to by the previous speaker, is that when you are proven as not proven, and that's a verdict that exists, right? Someone believes you're guilty, insufficient evidence, you already lose political capital to lobby for a further trial in the future because someone's judgment and biases against you is already overwhelming, and you cannot trust any jury in the future. You cannot trust anyone else in the future, especially if you are given new evidence. But the second reason is it's very difficult for you to have any second trial in the first place because you need to prove evidence of mistrials or wrongful practice in the first trial, which usually did not happen. For these reasons, we win the delta.
We thank the Deputy Leader of the Opposition for that fine speech, and we now call upon the Member of Government to open the bottom half of this debate. Hear, hear.
Can you hear me?
Yes, you're audible.
Okay, I'd like POIs in chat. If I don't respond by 5th minute, please unmute yourself and then ask me verbally in the Zoom call. Okay, so I'm starting in 3, 2, 1, go. Time for the big brain extension. Notice the info slide says the decision is that you're not guilty, and that's in Scots law specifically, this means that the jury does this. Notice in continental system, the judge still says, based on the facts, you're not guilty or you're guilty. So it's not proven or proven. This system in the 16th, 17th, 18th century also existed in France, Germany, etc. So it is possible for a judge to say, I do not believe you're innocent. However, I'm still not sure if you're proven guilty. So regardless of the jury, it is still possible to have a continental system where this exists. So notice why this is so crucial. And the slide itself never says this is limited to Anglo-Saxon system. It simply says the use of non-proven verdicts in criminal courts. So why is this relevant? Specifically because it outframes a lot of the top half, OG mostly. Because if the continental system, which is a majority of the systems in the world, meaning the judge makes the entire decision, the judge needs to explain the decision both based on facts and the law. So why is this crucial? Because the judge needs to explain what facts were proven, what facts were not. So therefore, all of the ideas about transparency, etc., aren't really that relevant, and the judges necessarily need to explain how they reached this decision. And this decision based on facts can be very easily scrutinized and is scrutinized. So why is this so crucial here in this debate? This means that discrimination as a point is less relevant because in a majority of the systems, it simply doesn't matter. And in the instances it does, when you have very close, for example, when it's very close margins, we will explain how specifically your unconscious biases are the ones that bring an issue to you. Point number 2, why specifically giving a you're not guilty verdict is so detrimental to everything. And I'm very surprised no team ever explained this. When you say someone is not guilty, you do something that's called the Nebby in idem principle. You can never, ever, ever try them again for the same crime or a crime that is connected with that one. So specifically that act. This means that after this one, we can never do anything. Even if I have a picture of this person killing someone, if this person was pronounced not guilty, we can never, ever change this because all of the legal systems, I mean, not authoritarian systems, but all of the relative democratic systems follow this. This means that the government simply refuses to go after people they at that point absolutely know they're guilty. We say this is a huge harm because OG does mention the example of O.J. Simpson, but they never really explain this. Because at that point, everyone knows that this individual is guilty. Everyone knows that the government did absolutely nothing to stop them. And what's worse, they're refusing to do it in the future. For some stupid principle nobody understands, they're saying, oh, but I won't trial him, even though we all know he's guilty. So they admit to this person being guilty because they cannot refute it, but they still refuse to engage. This means that then individuals lose trust in the system because the system is seen as not doing its job, even when all the prerequisites are filled. So the idea is you can try him. You know everything you need, but you still refuse to do this. At that point, victims are less likely to come out. Individuals are less likely to testify in court. Abuse victims do not go to court because they know I do not have enough evidence now and later I might not. And that leads me towards my second point. how to fight against power, specifically in the case of sexual abuse. I think that OO clearly doesn't understand how this works. A lot of these cases, as they concede, go out of court because there is not enough evidence. Mostly it's one woman against one man, and likely her story is very believable. She's likely had trauma, psychologists likely agree. However, the jury doesn't have enough evidence because it's one word versus one word. You always have doubt. In these instances, it is extremely difficult to get a decision that says this person is guilty, simply because you can never reach it's very difficult to reach this threshold. You need time, but you also need other evidence. You need other people who speak out against this person. However, if you get a trial that's not guilty in the first round, then other victims of the same person are less likely to speak out. And this individual that was harmed is then going to believe, look, I tried everything. I put myself to harm, and I still got a not guilty decision, and I will never be able to do anything. We believe that this is abhorrent from the opening opposition, and it is also an abhorrent system which systematically discriminates against abuse victims who do not have power. So what is the difference here? We get likely a not proven decision. This means that other victims also see that this was not proven, which then gives them an opportunity to voice their concerns, to say what happened to them, and in doing so have a larger action, saying, look at all of us that were abused. It's no longer one word against one word, it is all of us. But the crucial part is, here they see that the judge and the jury are likely to believe them because they said non-proven. Now notice why this happens. Because specifically, it's easier to connect with the victim. However, the threshold of no reasonable doubt is something that cannot be reached in these types of circumstances. Point number two, what happens with minorities and discriminated people? So the idea is not that you're prejudiced, you do not communicate with the public. The issue is your own intuition. You as an individual, if you're discriminatory, this also applies to judges to a certain extent, but also to juries, then your idea is this person cannot be innocent. Look at him, he's from a minority, he's definitely a thief, which is horrible, but still happens. And therefore you have weighing to do. I will take opening.
So can you just explain how this outweighs the material you've already brought about how people lose trust because they already have to pass the barrier of proving not proven, which is considerably higher than everything else you mentioned?
So the idea is the following. So if you believe that this person cannot be innocent and you believe it is likely that they are a thief, you have a choice of saying they're either innocent and then I'm letting a guilty person walk away forever, or I'm guilty. Or this person is guilty, which I'm not sure, but it's likely. At that point, you as an individual are likely to go for guilty because you believe your intuition. However, if we offer you it's not proven, then we say, look at the bar of no reasonable doubt. It's so hard to prove. You cannot have a single doubt in your mind. And then you as an individual, both as a judge and as a jury member, finally understand what it means. That this person is definitely guilty. I have no other evidence. It's not only my belief and my intuition. At that point, you're less likely to convict. Now, notice a simple way of that happens here. Even if we get more people that are proven not proven, we believe that the harm to them is minor compared to everything that happens if you're proven guilty. Because if you're proven guilty, you go to jail to a long run. However, if you're not proven, your local community will still believe that you're not guilty because they know your story, they know what happened if you're not guilty. Other people are unlikely to know about this decision anyway, because if you're not proven, then it's not a guilty decision. It's not going to be published to everyone everywhere. And this is why you don't get the significant harm. For these reasons, you vote CG. Thank you.
We thank the member of government for that fine speech. We now call upon the member of opposition to begin the case for closing opposition. Hear, hear.
Am I audible clearly?
Yes, you're audible.
Okay, starting my speech in 3, 2, 1. Panel main extension is on victims and whether they can find closure. We're gonna explain to you why the most vulnerable, most wronged person just experiences it very differently. Whether they get at government's best, maybe a not proven verdict instead of a not guilty verdict, and why it is easier for them to make peace. and move on at that point, rather than then they're presented with, there's just this one thing missing. We're believing you, but we just want this one thing to be able to go forward with this. Before I go into that, some extraneous rebuttal. So like, we think on the idea that like the legal system like just doesn't like manage to move forward. Like we think most people working in this, like the police, the like prosecutors, etc., they're reasonably experienced. They can somewhat assess whether they reasonably find more evidence. They can also within a trial request a recess, etc., to do that collection and find as much as they're probably like ever going to be having, and like usually are trying to like take their one shot as possibly like as well as possibly and like doable, and like probably are like able to prove it relatively well on their first try in most cases anyway. They don't want them to walk free. We also think like actually most trials like will probably not change, especially on the side where you can prove guilt, because just there's somewhat emotional instinct that people feel quite wronged by criminals. They don't want them to walk free. We think jurors still are likely to want to put them to prison where they can and where this is proven quite highly. And then like we think like just on all of the ideas that like opening governments has of like less gut instincts, we think by like including this very fuzzy metric of saying very explicitly like we don't actually have the evidence to prove this, but if you think this person is kind of guilty, you can like put this label on them, probably just introduces more gut instinct. We think in the cases like we think people are like fundamentally just very bad at evaluating this well, like fall into like biases, etc. So like, why is this like really bad for closure? We think in status quo, like, of course, it is like still horrible to be the victim of a crime or like be close to someone who was the victim of a crime, etc., and feel like wronged and unjust. But we think that actually there is a like pretty big difference in being presented with a not guilty frame or just the idea that you couldn't convict on like what you have or that you're not sure. It is like much less likely that you have like a clear trial. You see like it didn't work, but there's just a general unsureness that is communicated by the jury. Like the jury might not believe it, that you might actually have the wrong person. This might just not be the person. You will often like in these situations also not be entirely sure, because if you had fully witnessed it, etc., it would probably be relatively easy to like fully prove it. So these are often situations where you don't even clearly have a person to put through like like the person who did the crime to you. I'm bad at English today. We think that like communicates a certain insecurity that is still bad, but we think it is much worse than being presented with like a very specific person and a very clear mission of like exactly just needing that evidence. Before I go into that, I'm also going to say that like we think this often will lead you to attach this to the wrong person when you are like given the frame that like specifically under the idea that like this gut instinct metric and like just general structural racism will often mean that the jury will attach this to someone who can't actually be clearly pinned on this crime. Like the person who like broke into your house and like by that like made you feel violated for like your privacy and by taking your possessions, and there was just like circumstantially some like a black man in the area who was like somewhat possible to be tied to it, but not really, but due to their biases, due to like what was communicated about his character in the trial, whatever, the jurors got convinced that he probably did it and therefore like go for a like relatively unwarranted not proven verdict instead of just saying not guilty, we can't actually prove this. You think this often, like these kinds of situations, then communicate to the victim that this was probably the person. They are like likely to not follow the trial and the investigation as closely as the jurors. They are likely to just like A, not have the time to engage with all of this, but also B, like often not have the mental energy to want to like read through all of the evidence, see all of this. They're rather just presented with like the trial. And we think like in many situations, it is like easier for you to be presented with like, unfortunately, we can't establish clarity here. We don't really know who it is, and you have to move on. And then for that person, knowing that this is like the easiest way for them to go on to pursue therapy, to like pursue closure and self-help and just like move on with their lives and somewhat make their peace as much as they can at the point at which we probably can't offer them justice. Rather than being told by those who know best, the people who spend weeks of their lives sorting through the evidence and looking at everything, telling you, we actually think it is this person, we just don't quite have enough to declare them guilty. We think this is bad insofar that this gives you like this very clear frame and this very clear mission that it like A, probably was that person and gives you like an object of hate. And B, like this idea of being like wronged in this very specific way, but in a way that you feel like you could somehow change, or like where you somehow have this idea of like an angle to solve it, and just go for the evidence. We think the like inherent wrongness that people perceive from a crime that has happened to them, like the violation that they perceive and like the emotional pain, is likely to turn into them very strongly wanting this to be pursued. And as long as they can like see this clear angle, see this clear person, they will feel like there's some revenge here. We think this is like communicated in just also the popularity of revenge narratives, something that people are like exposed to here, and they often like find hard to like live with. They like try to like deal with their pain by like coming after that, to like making it their mission to like find that evidence, like spend a lot of their time researching this, spend a lot of their time, money, hiring an investigator, going to the police very often and crying on this. We think the like impact of this is that this becomes a part of your life, and every day something that you deal with, just trying to hunt down that evidence, trying to find the piece that will finally get you justice on that person. We think this is like on the long run a much worse mental state for the victim to live in than just the idea that you need to move on, and we unfortunately can't clearly establish something here. We also think this like hate specifically projected to a person is more likely to like motivate you to lead the whole community against them, to like try to find evidence, harass them, to like try to get other people in on this in general, to make that person's life harder, which is probably also again another impact that happens on somebody who often like innocently gets accused and just on gut feeling have this put on them, vote CO.
We thank the member of opposition for that fine speech, and we now call upon Government Whip to close the case for side government. Hear, hear.
Hey, just to check, you can hear Petrović? Okay, just to check.
Yep, you're audible.
Great. Let me just sort my notes into something that makes sense, at least to me. Great. I will start in 3, 2, 1. Panel, a boring structure. COO, then basically talking about our extension, why is the best thing you have heard all day. Look, let's try to get some more external rebuttal on closing opposition, because their main claim is that if you are a victim and you hear not proven instead of innocent, then you will constantly try to find new evidence, you won't get closure for that, etc. 3 responses. 1, I think not proven is more calming for you, because when you hear, oh, they are innocent, this means that the judge and the jury and the system is telling you, you were wrong. We believe that you have falsely accused a person of doing something to you. At least on our side of the house, you get the closure of knowing that the jury and the judge agree with you, right? They believe you, they know you were the victim. You were just unlucky in the way that this turned out. We know he did this to you. There is no evidence to find. And this is unfortunate, but at least you know you're not going to be called a liar. You're not going to be called out and told you're basically trying to get someone falsely accused. Secondly, the question of safety. When you know that there's a chance that this person who can be tried again for this crime, this means that you know that if they were to attempt to commit that crime again, it would be much easier to convict them. It is much less likely for this person to try and do this again. And then you know as the victim that you're much more safe. And this is the main thing that you're trying to, that you worry about. You have lived through a trauma, but you know it's unlikely for it to happen again. If they are called innocent, they cannot be tried for this again. And they have been proven innocent once in the past. It's much harder for any judge or jury to say that they're guilty later on. But thirdly, weighing, because even if closing opposition is right, I don't think this weighs with the government bench at all, because when we prove to you that because there is a loss of trust in the system, therefore less victims come out, you get less people convicted and getting that actual closure of sending people to prison or being fined, or getting new evidence later on to get people convicted again, getting actual closure. That means that on the mention of closing opposition or bringing closure to the victims, they lose out because they never weigh themselves against benefits of the government benches. Secondly, about opening opposition. Look, opening opposition has 2 main claims. One, that people with money will wiggle out of a guilty verdict into a not proven one. And secondly, that there's a black mark on your record that's horrible for you. Firstly, about rich people. One, recognize that they give a lot of, and very good analysis, because I want to repeat it, a lot of substantial analysis of why rich people are more powerful in courts, why the bias is in their favor, right? If that is the fucking case, I think their margin is really small, because most rich people get innocent anyways. Most rich people do not get a guilty verdict. They are already able to, and they do use all the tactics that they have mentioned in order to be able to do this, right? What's the comparative now? The comparative, there are two main ones. One, that you can sue them again if you get new evidence. This is when their margin is this small, this is important, because now we can get new evidence, we can get new videotapes, new witnesses. When people come out and say they are not proven, we know they're guilty, but we need new evidence, we need something more concrete. It's more likely that more people stand up against an abusive boss and say, look, he did this to me as well. Because before, you're afraid people were going to call you a liar. Now you know that the people agree with you, they just need more evidence in order to do this. But yeah, but also secondly, I think that when you talk about how does this work? So the way that this works is that let's just go. I think that that point is that because they narrow themselves against the idea of we can get new evidence out of this, right? But secondly, about the black mark on your record, I think this doesn't happen. I think this is like one thing that sometimes exists in the US and then people believe it's in the whole world. The most of the world in the way that the legal system works is that they do not publicly announce what happened to you. These are not public trials, and court records are hidden from the public, right? Especially with the precedent that we have, not proven will be public, because the only way you can demand if you know someone is they were convicted. Not proven will not stop you from getting employed. No one in your local community will care because they trust you as a fucking person. They know you haven't done it, just that judge fucking you over. And I don't think that has a big impact later on in life. Let's get to our case and how this turns out. I think when you get to about how the trust in the system works, and why this is, I think, a significant thing that we should take in. The comparative here is that we, as a system and the state, say, this person is guilty, we couldn't get him this time, but we will. We will get more evidence, we will do something more, we will repeat this, and we will send them to prison, right? We're just unlucky this time. What's the impact of this? The impact is that you're now encouraging victims, both in that case, but in other cases and witnesses, to come out, because they know that the system needs more evidence, it needs as much stuff as possible in order to convict people and send them to jail. Because otherwise, you believe that the system is rigged, because they just said that the person that everyone knows is guilty is innocent. At the point where you're explicitly lying to your people, as you do on the side of opposition bench, then your people in general are less likely to come out and are just less likely to call the police, less likely to trust the system, right? And I think this is a really important impact in this debate, because this gives us new trials, new convictions, and new chances to put oppressors in prison. Weighing this with the opposition bench, it is more important, because even if someone who's poor gets not proven, or someone who's really rich maybe gets not proven, the point is that we get more trials, more chances to put the actual guilty people in jail. Before I go opening up.
So it's not clear why people would be incentivized to have more evidence, given that it's the job of lawyers to do this anyway. But the difference is that now people are less confident in it, because you're admitting basically you couldn't get enough evidence in situations where you couldn't.
Stupid. The thing is that if my boss sexually harasses me and I take them to court and the court says not proven, then my co-workers are more likely to come in and say, oh, the court is side, they need our help to give us those witnesses, right? If they say innocent, then if I'm also a sexual abuse victim, I know I'm going to get fucked over, because the court system is on the side of the rich person. Later on, about abuse victims. Look, I think this often comes down to the idea that this is one person's word against another, right? Which means it is really difficult to get beyond reasonable doubt. Therefore, people are just unlikely to talk it out and testify, because they don't believe you can get to that point. Not proven, victims see that they can believe, more likely to speak out, easy to convict. But thirdly, about minorities. I think that we just go over-OGing this, because we avoid always rebuttal, because it's based on this being a system with juries. But Luka gives you the idea that it's not about jury selection and unanimous votes. It's about the unconscious bias of a judge, that it has the intuition, this person is guilty, and even though I don't have enough evidence, I cannot say he's innocent. It is immoral for me to say he's innocent, therefore giving them a guilty verdict. On our side of the house, we give the judges the options to come in and say, look, I know you're guilty, but you're not proven. Comparative, much better, because an innocent person doesn't go to jail. Vote closing government.
We thank the government whip for that fine speech, and we now call upon the opposition whip to close the case for side opposition and the debate as a whole. Hear, hear.
Cool, just checking. Can you hear me?
Yep, you're audible.
Give me a second to grab my notes from where I chucked them halfway across the floor 5 minutes ago. Turns out I needed those. Okay. POI is ideally on camera. I'll try and look at chat, but I will be bad at it. Okay. In 3, 2, 1. To quote or to basically paraphrase the recent speaker, very boring structure here. I'm going to go CG, OG, OO. Explain why we beat all of them. Specifically explain why like the bar for proving any of OGRAV for prevention's benefits was incredibly high, why they didn't cross it. Content warning for, like, as with most speeches, for like sexual harassment discussion in the speech. Okay. Before I do that, a few extraneous points of rebuttal to the responses to Lena's speech that we just heard from the most recent speaker, right? So first of all, they say that not proven is more calming for you because it is the feeling that you are validated, right? I think it is far more distressing to feel like you are right and to feel like that is not being reflected in the legal system. Note, this was their case. They cannot have both claims simultaneously, right? I think that like the idea that is calming to you is incredibly tenuous, right? Like I think specifically, like if you I just don't think that lands, right? Just insofar as I believe that like under our side, at least, even if like most victims are unlikely to concede to the idea, or at least initially, or are likely to want to buy into their intuition that they are in the right, they are at least willing to accept that there's nothing more that they can be done about it within the judicial system, which means that they're more open to doing things like going to counseling, like going on with their lives, right? I think that is a unique benefit we claim under our side. Second thing they say is that the feeling of safety, right? Now you know that if they try and recommit the crime, then you they can still be prosecuted. Note, if they recommit the crime, that is a separate instance of the crime that they can still be prosecuted for. The feeling of safety is probably pretty symmetric, but also it's probably pretty symmetrically low because you're like just at, like for everyone, regardless of like what the specific word of the law says, at the point at which like your privacy, like at the point at which your security has been violated, you're just going to feel pretty bad. This is a harm that both sides are going to have to accept. Okay, with that out of the way. On CG's case, I'll take a POI at like 5:30. Like so CG tell us a couple of things, right? They tell us first of all that like you are like incredibly likely to like cause a waning in trust in the judicial system, at the point at which like there are people who the entirety of society knows are like obviously guilty, but the legal system cannot prosecute them because they don't have enough evidence. Note that I think in order for them to actually land with this impact, there were several things that they needed to prove that they didn't, right? One, they needed to prove that finding damning evidence after the trial is concluded is particularly likely. There was no analysis given. Lena told you several things from this. She told you one, that first of all, that recesses can be called in trials if there is any likelihood of finding for future evidence. These recesses, note, can last a particularly long time, right? Like trials can be suspended for 5-6 weeks, right? Like note that I think all of the individuals participated probably have a pretty high incentive to try and find this evidence, just insofar as like Lena explained to you that like moralistically people are coded with the value that if they are convinced someone is guilty, they're going to be unwilling to accept that that person goes free, so they will try their absolute best to find this evidence, right? I think this means that like it is incredibly unlikely, especially given these recesses can be called at multiple points during the trial. Like you can have multiple recesses called for each new instance where you identify an opportunity to find further evidence, right? I think it's incredibly unlikely that you find damning evidence after the trial. I think secondly, right, they needed to prove that that these sorts of trials get a large enough platform in order for them to for this to like have any kind of significant impact just on the perception of society of the judicial system, right? Note that like I think the reason that both gov benches use the exact same fucking example is because there is only one within any of the any recent memory, right? Like I think it is like specifically the case that like most of these in most public trials, like there is like some degree of debate, right? Like the reason they get loads publicized, the reason that the media likes to platform them so much is because they know that there's going to be a debate, there's going to be a controversy, right? Like you very rarely, unless it is someone like giga famous, like you very rarely get trials being platformed that are just entirely uncontroversial, because uncontroversial trials are boring, right? Like I think but also just most trials as a statement of fact are not publicized within major media, which means that like their ability to affect the way that most most people perceive justice is incredibly low. Finally, then on when they talk about the sexual harassment claims, right? Note that I think that the audience, the final thing they needed to prove is that this is the tipping point between people going forward and not going forward. Note that I think there are a number of other incredibly unfortunate barriers to this shit like this, right? And it is the fact that men will just not take you seriously. In fact, it is the fact that people will slut shame you. It is the fact that the police will just laugh at you and very often won't file your reports. These are all things that this motion does not change. I don't think this is ever a tipping point for them. CG out of the debate. But let's talk about OG. Okay. OG say a couple of things, right? And it's kind of weird because OG simultaneously, I'll give you a chance to respond right after this. OG simultaneously say that the norm for trials is innocent until proven guilty, and this allows for rich to sway trials, and also say that minorities under status quo get convicted guilty because of biases now have another option, the existence of this not proven verdict. Note that I think, like, insofar as the norm is innocent until proven guilty, right? I think these biases have to have an incredible degree of strength, an incredible degree of sway over the decisions of jurors in order to allow them to wrongfully convict somebody on the basis of biases alone. I think if these biases have that much degree of sway, one, like OO gave a bunch of competent responses to this, right? Like, OO, we're good at this. They said, like, okay, yeah, you're unlikely to have 10 jurors who are this way. But also to know that I POI'd this, and OG never responded, like that, like. If these biases were this strong anyway, you're going to get a wrongful guilty conviction under either world. They never proved anything there. OG, I'll give you a chance to respond. Oh, you're muted.
Victim's closure is a wash at best because it depends upon the nature of society, case, and decision. What is unanimous, however, is the quality of decisions when jury have to vote on limited evidence is better when you have a third option as opposed to two. Please respond.
Okay, no. So, like, I don't know why the idea, like, the aspect of needing closure at the point at which you feel like you have been violated is culturally dependent, right? Lena gives you plenty of reasons why you're always going to feel like this and why this is always going to get a lot worse under, like, at the point at which you feel like you just need one more thing, at the point at which you like now have start to obsess and are single-mindedly fixed on the idea that you can get justice for yourself if you only find this one more thing, even when that one more thing doesn't actually exist, right? I don't know why this is explicit. I've also just rebutted like the idea that they get better get better responses like from on OG, right? Finally, then let's talk about Lena's case and weigh it up versus our opening, right? Well, because no, like, opening one is like a case like which is to a significant degree about the idea that like game theory problems mean you get loads of like not proven verdicts, and not proven verdicts are just bad for you insofar as they are a black mark on your CV, insofar as they harm your ability to get employed, your future, right? Note CG probably accurately frame a response in that like trials are not publicized most of the time, like, which is also fatal for their case, but that means that like that heavily mitigates opening's case. I think what Lena exclusively proves is that the point at which you feel validated, you feel like you are right, and you feel like you just needed that one extra point of evidence, you are likely to go on the warpath against this person. This is the point at which you are likely to lead your community against them. This is the point at which now everybody knows about this not proven verdict, and now this is a black mark on your CV. We co-opt all of opening ops benefits. Look, there's just only one vote in this debate.
We thank the opposition whip for that fine speech and to all of the speakers in this debate. We're now going to adjudicate, so I guess you guys can go take a break. The results will probably be out on Discord, I'm assuming. Thank you.
Thanks for the debate.
For the round.
Thanks for the round.